Madam Speaker, by way of background, Amnesty has made some very good recommendations for the country, including to ASEAN Parliament. I'm allowed to do this. That we repeal the immunities provided for in Section 155 to 158 of the Constitution. That we amend Section 65 of the Prisoners Act to ensure that military and police officers are not given special treatment. To the Constitutional Officers Commission, it is recommending that we appoint a Commissioner of Police and Commissioner of Correction for civilian with integrity.
Can you just read the question that is here, please?
And the question is, what are we doing in relation to these recommendations? And others. There are many more.
Honourable members, the 1 minute timeline is given only to supplementary questions. But these questions have already been approved and these have to be read out. Thank you. I give the floor to the Honourable Attorney-General, Minister for Economy, Public Enterprises, Civil Service and Communications.
Thank you, Madam Speaker. Madam Speaker, I'll take some time to answer this question, Madam Speaker. Madam Speaker, what the Honourable Nawaikula tried to slip in is something that I was going to highlight, which is the recommendations made by the Amnesty International Report. And if I can tell the Honourable House, Amnesty International actually made recommendations both to Parliament, to the DPP's office, Constitutional Officers Commission, the Police Commissioner, RFMF Commander, Corrections Commissioner, and the Minister for Defence and National Security. These were the recommendations that they made. To the Fijian Parliament, and let me read out, they said, and I quote, address the significant gaps and consolidate the various laws on policing powers and the use of force and ensure that torture, cruel, degrading, inhumane treatment is adequately defined in law in recognition of the gravity of the offence. 2, remove legal barriers to the prosecution of torture and other ill treatment, including by repealing immunities, provide Section 155 to 158 of the Constitution, amending Section 65 of the Prisons Act to ensure that military and prison officers are not given special treatment through early release if convicted of offences, and C, amending the definition of torture under the Crimes Decree to ensure it complies with international human rights law and that penalties reflect the gravity of the offence. 3, repeal the Public Order Amendment Decree. 4, immediately withdraw Fiji's reservation to the Convention Against Torture, ratify and implement the optional protocol to Convention Against Torture. They are the recommendations. Madam Speaker, the fact of the matter is that this report was presented by Amnesty International is legally biased and is factually flawed. And in fact, I'll come to that, and lacks intellectual integrity. Amnesty International, Madam Speaker, in particular since 2008 or so, has been blatantly making sweeping generalizations and statements which are blatantly incorrect, in particular through the researcher Kate Schutz, who worked for CCF before. Madam Speaker, we find it difficult to give credence to a report which still refers to the Republic of Fiji Military Forces as the Royal Fiji Military Forces. The last time we checked, Madam Speaker, we became independent and we are no longer a British colony. In fact, we became a republic about 30 years ago. If Amnesty International wants to write about Fiji at the very least, in particular since 2008, they should be able to get the names of the institutions they want to write about right. The issues, I'll come to the major issues. The issues highlighted in the report, Madam Speaker, the issues highlighted in the report deal with torture and police brutality. The Fijian government, indeed the Fijian Prime Minister, has publicly stated on many occasions, and let me quote, and the Honourable Prime Minister said this, when the United Nations used Fiji as a case example for other Pacific Island countries as to how to ratify UNCAT. And there's a workshop held at Natandola, in which the Honourable Prime Minister said, we have long had a culture in Fiji of people resorting to violence, whether it is against women in the home, instilling discipline in our children, or the police attempting to extract confessions from criminal suspects. The culture, what we call buturaki, the beating, is deeply ingrained in parts of the Fijian psyche. Unquote. The Fijian government, Madam Speaker, has acknowledged this. No other Fijian government has ever said this. No other Fijian Prime Minister has even publicly acknowledged this. So, Madam Speaker, to say that government should actually come up with this culture and change the culture is factually incorrect, because we have. And Madam Speaker, there is no state-sanctioned policy of torture in Fiji, unlike in other countries, which they look up to as the greatest form of democracy or forms of jurisdictions that have all these rights that we don't have. The USA has state-sanctioned policy of waterboarding. There are numerous other states that we can name that actually have the Supreme Courts allow torture for example, protection of sovereignty. The Supreme Court of Israel has said torture is allowed if it's to do with the protection of the state of Israel. Australia allows for the putting on of tracking devices for suspects of terrorism. And other countries, we can go on, the list goes on. Madam Speaker, the fact is there's no state-sanctioned policy of torture. What we have had, Madam Speaker, on occasional problems with individuals or groups of people taking the law in their own hands and violating the human rights of others. But I repeat, no act of torture or cruel, inhumane or degrading treatment has been sanctioned by the state. And as I've said, this is in stark contrast with many other countries in the world. Madam Speaker, waterboarding was only recently stopped by Barack Obama when he was in his second term of government to stop waterboarding, and we understand the current administration thinks otherwise. Madam Speaker, Fiji has a robust legal framework to protect all Fijians from torture. Firstly, the Fijian Constitution, our supreme law, prohibits torture in our Bill of Rights, and in very precise terms, Section 11 unequivocally states this, that, and I quote, every person has the right to freedom from torture of any kind, whether physical, mental, or emotional, and from cruel, inhumane, degrading, or disproportionately severe treatment or punishment. Madam Speaker, this definition of torture, which is very large, very encompassing, in fact goes beyond the definition of torture in Article 1 in UNCAT. United Nations Convention Against Torture, the definition of torture is more limited than ours. We actually talk about mental or emotional torture. Madam Speaker, it further states that every person, the Constitution, every person has a right to security of the person, which includes the right to be free from any form of violence from any source at home, school, work, or in any other place. This is the extent of the legal definition and the applicability of the law and the gambit of the law as far as torture is concerned, as far as cruel, inhumane, degrading, or disproportionately severe treatment or punishment is concerned. Madam Speaker, as I've said, the statement of our values as a nation establishes for the Fijian people one of the strongest constitutional protections against torture in the world. In fact, our reservation to Article 1 of UNCAT is based on the fact that our own definition of torture is actually broader than that covered by the Convention, as I've stated earlier on, because it extends specific protection for our citizens at home, at school, and work. And many people, some of the lawyers in this room would know that for many decades in Fiji, violence at home was seen as the domain of the private sphere. In other words, that the state, that this House, this Parliament had no domain in the home domain. It was seen as the private sphere, and the public law could not apply that. That has changed. And that started off, Madam Speaker, when the Bainimarama government brought about the new crimes decree, getting rid of the old penal code that got rid of, for example, the old Victorian rules pertaining to rape. The rules of corroboration was removed by the Bainimarama government. And the definition, for example, of rape, which always fell, a lot of it was followed by or post the rape of cruel, degrading treatment. It became a lot more encompassing. Madam Speaker, the government, of course, does not tolerate human rights abuses of any kind. They are legally and morally unacceptable, and we are determined to bring the perpetrators of such abuses to justice. The record shows that we are doing so and that our laws are being enforced. Recently, there were, Honorable Nawaikula would know this, recently we had some former police officers and a military officer that was actually found guilty of certain offences. This goes to show that the process is independent. This goes to show that the system is working. And again, it brings into question this Amnesty International report, and I'll tell you what are the other flaws. There's a recommendation, as I read out, by Amnesty International to say, quote, remove legal barriers to the prosecution of torture and other ill treatment. What sort of legal barrier is there when you recently had these kind of prosecutions undertaken? The researcher from Amnesty International did not even go and meet the DPP, but wrote a report on the DPP. Only after we highlighted, after the report was released to the public, then she went and sat outside his office trying to meet up with him to try and correct something that she had done wrong. And he refused to meet her because she's already cast aspersions. So how can you rely, and the whole nature of writing such reports is going to meet up with the various stakeholders. Yes, she came and met up with our office, but she did not go and meet up with the DPP's office. Of course I know that. I've confirmed that with the DPP's office. We've checked all of this, Madam Speaker. The reality is that, you see, these people, they come to this parliament with preconceived ideas and they want to fit everything into it. When it falls out, then they ask very, unrelated questions. And let me read out something else, Madam Speaker. It goes on about sections 155 to 158, about the immunity provisions. Again, Honorable Nawaikula, who's a lawyer, should actually be able to understand this. I'm beginning to doubt the level of understanding that does exist. Because it does provide, Madam Speaker, the immunity provisions, Madam Speaker, relates to 1987. Relates to 1987. Then it relates to the events of 2006. But then, Madam Speaker, he fails to read the second part. He says, immunity is given, etc., 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 from criminal prosecution and from any civil or other liability in any court, tribunal, commission, or in any proceedings, including any legal, military, disciplinary, or professional proceedings, and from any order or judgment of any court, tribunal, or commission. Have I lost you yet? As a result of any direct or indirect participation, appointment, or involvement in the government from 5 December 2006 to the date of the first sitting of the first parliament elected after the commencement of this constitution. Provided, however, any such immunity shall not apply to any act or omission that constitutes an offence under sections 133 to 146, 148 to 236, 288 to 351, 356 to 361, 364 to 374, 377 to 386 of the Crimes Decree, as described in the Crimes Decree 2009, the date of the commencement of the Constitution. What are they, Honourable Speaker? They relate to criminal offences. There is no immunity for those criminal offences, and I'm not here to sit and enunciate all of those offences. Honourable Nawaikula should know this because it's a criminal matter. Madam Speaker, the fact that... no, but yes. Madam Speaker, let me also point out, so that observation of the Amnesty International is flawed, because it says that immunity is given for criminal offences, but it's not, because the Constitution is quite specific on that. The other recommendation, Madam Speaker, it says, quote, the amendment of section 56 of the Prisons Act to ensure that the military and police officers are not given special treatment through early release if convicted of offences. Madam Speaker, the Prisons Act was repealed 8 years ago. The Prisons Act was repealed 8 years ago, and Amnesty International talks about the Prisons Act. It was repealed 8 years ago. That act no longer exists. So how can they refer to that act? In fact, the Prisons Act, Madam Speaker, 8 years ago was replaced by the Correction Services Act, 2006, which we brought into effect under the Bainimarama government, and it is only 56 sections. So by their reference to the Prisons Act saying we must comply with it, the fact that it's repealed means that we have complied with it, because we repealed it. We repealed 8 years ago. The fact of the matter is, and Honourable Nawaikula and those of you who were very close to the government prior to 5 December 2006 would know that prior to that, the minister under section 65(1) of the Prisons Act at that time, it said the minister may at any time in his discretion direct that a prisoner shall be released on an order of compulsory supervision for such period as the minister may think fit, and the controller shall forthwith comply with such directions. That's what existed previously. That's what existed previously, and we know certain ministers used that after 2000, the events of 2000. We know that. Now, the minister responsible does not have that discretion anymore, because we changed that. Madam Speaker, what the Honourable Nawaikula also fails to mention, that under the Beni Marama government, we are answering the question, Madam Speaker, under the Beni Marama government, we also removed the reservation that was put in place by the Alliance government on the Convention of the Elimination of Racial Discrimination. And I think it's Article 12. We removed that reservation because they had that reservation, and other reports have also talked about it. We had that reservation because we said we can't discriminate on the basis of ethnicity in elections, because that's what our constitution said previously. So they put a reservation to that. We removed that reservation. Madam Speaker, let me put it into context. And I would wish to read out certain observations when Amnesty International Report used to have a bit of credibility. That was before 5 December 2006. And let me read out one observation of Amnesty International Report of 2004. 2003. I'll read out 4 or 3 years. 2003. Political considerations continue to undermine, and I'm quoting, to undermine the respect for constitutional human rights and the rule of law. People responsible for coup-related racist violence, torture, and extrajudicial executions continued to enjoy effective impunity, while others were convicted in proceedings which avoided evidence on human rights violations and abuses being presented in court. Indo-Fijians were effectively internally displaced, after some being illegally evicted from leased indigenous land. This is an Amnesty International report in 2003. Honourable Leader of Opposition was in Parliament then. I wonder what the Parliament did then about it. Amnesty International Report 2004 said, and I quote, "The government pursued a policy of encouraging indigenous Fijian dominance over main Indo-Fijian non-indigenous community. Many supporters of the coup in 2000 and the rebel soldiers were convicted in prison, but others continued to enjoy immunity." Honourable Nawaikula maybe knows maybe some of them. The police, military and civilian justice systems struggled with the investigations and prosecution of coup-related criminal cases, including those involving human rights violations, unquote. Amnesty International Report 2005, quote, "The government continued its policy of favouring indigenous Fijians over the mainly Indo-Fijian non-indigenous community. Judges, state witnesses and journalists were anonymously threatened because of their work on high-profile coup trials. One witness lost her job at a government newspaper. Discrimination against ethnic minorities was evident in plans for an indigenous trust fund and in the appointment of indigenous Fijians to almost all chief executive posts in the public service," unquote. Madam Speaker, these are the observations of Amnesty International report of Amnesty International in those years. The fact of the matter is that this report that has been put out by Amnesty International this year, which Honourable Nawaikula is bandering around, Madam Speaker, is factually and legally flawed. These reports, the observations raised about Parliament, have in fact all been addressed, Madam Speaker. And the government has categorically, through the Honourable Prime Minister, stated on a number of occasions, there is no state-sponsored torture. And we have unequivocally gone out into the public and said this. Laws have been put in place to ensure that it does not happen. The independence of the different offices that exist ensures that this will follow a very clear and transparent process, Madam Speaker. And, Madam Speaker, the other point is that government together now, in particular the Fiji Police Force, with the great assistance of the British government, for example, the Honourable Minister for Defence can also confirm this, has now been receiving training from Scotland Yard in respect of what we call the first hour procedure. So the Legal Aid Commission is working together with the Fiji Police Force and the British government and Scotland Yard in respect of what we call the first hour procedure. And this project ensures that all suspects at the police stations have actual access to a lawyer within 1 hour of arrest, and that the police should hold off interviewing until the accused or detained person has spoken to a legal practitioner as provided for under Section 13. Madam Speaker, we have also, as highlighted at the Attorney General's conference, we have reached out, also through the Legal Aid Commission, to private practitioners, private legal practitioners. Honourable Nawaikula can also join up on this, where we are offering positions to lawyers who want to volunteer their services for free on what we call a roster basis. So there may be suspects who may be arrested in the evening and they want to be interviewed. We have lawyers on a roster basis. Australia does it, New Zealand does it, many other countries do it. Unfortunately, many lawyers in Fiji do not want to do it from the private practice. But Legal Aid Commission now, Madam Speaker, as mandated under the Constitution, provides the type of mechanism and that redress. So, Madam Speaker, this first hour procedure has arisen from the collaboration with the Geneva Bar Human Rights Commission and the OHCHR, which is the UN body. Funding for a visit to Geneva to see this scheme in the practice, which is only 2 years old in Geneva, came from the Association for the Prevention of Torture, who we are working very closely with. So, Madam Speaker, these question by Honourable Nawaikula has now been, I understand, addressed quite categorically. Thank you.
I give the floor to the Honourable Nawaikula.
Madam Speaker, taking all that statement into account, long and winding, totally wrong, erroneous, true only to him, can the Honourable Minister explain whether the government will implement the recommendations or not?
Honourable Attorney General.
Madam Speaker, again, you see, I really, actually, one of those occasions, I'm really lost for words on Honourable Nawaikula's question, because it's just so fundamentally, I'm looking for a word that is not going to be unparliamentary. Madam Speaker, it is so obtuse. It really is so obtuse. I have addressed those issues. It is so obtuse. Firstly, we pointed out, let me reiterate, Madam Speaker, 155 to 158 of the Constitution does not give immunity from criminal prosecution in those offences that I just read out. So the observation by the Amnesty International Report is wrong. How can we adhere to something that is wrong? Madam Speaker, secondly, it says amend Section 65 of the Prisons Act. How can we amend it when the Act does not exist? How can we amend an Act that does not exist? And he has the audacity to stand up and say, are you going to comply with it or not? How can we comply with something that does not exist? He's saying, are you going to go and catch up with a flying saucer? How can you go when the flying saucer is not there? Madam Speaker, amending the definition of torture, Madam Speaker, Honourable Karavaki, if I want to take his comment on, the Amnesty International report, when talking about the Prisons Act, actually talks specifically about Section 65. There's no Section 65. There is no equivalent of Section 65 in the Corrections Act. So how can we adhere to it? What they were concerned about, Madam Speaker, they were concerned about that the minister under the Prisons Act had the discretion to go and say, take this prisoner out, I'll put him out on community work order, irrespective of the offence. That discretion has been taken away from the minister. So what's there to comply with? Madam Speaker, the other point that they said, repeal the Public Order Amendment Decree as amended. That, as we highlighted, Honourable Salote Rondondo had walked out when I gave my response to her yesterday afternoon. She had said to repeal the entire thing. I'm not here to repeat everything I said. Repeal everything. That includes terrorism financing. It talks about arms and ammunition. This is how flawed it is. The amendment that they wanted, Madam Speaker, was in respect of meetings. And we have removed that, which they objected to yesterday. We no longer require a permit, which they objected to yesterday. So that's gone. Then they said immediately withdraw. Okay, this is the other recommendation, Honorable Nawaikula. So immediately withdraw Fiji's reservation to the Convention Against Torture and ratify the optional protocols. Right? Now, let me come to the reservation. Firstly, we have a reservation on Article 1. And we have explained that the definition of torture, this is actually becoming quite, comically tragic. Madam Speaker, the definition of torture in our Constitution is much wider than the definition in Article 1 of UNCAT. That's the reservation. Reservation, Article 14. New Zealand has a reservation to Article 14, Madam Speaker, which is about compensation. The extent to the right to award compensation to victims of an act of torture shall be subject to determination by a court of law. What we are saying, if somebody says, I have been tortured, you may have a criminal process to that. Then the person can claim against the state. What we are saying, yes, you can do that. Do it through the courts in Fiji. That's the reservation. Reservation by USA. USA has a reservation to Article 14 also. Reservation by Bangladesh. All these countries have a reservation to these articles. Again, Madam Speaker, Articles 20 and 30 reservations. China, Indonesia, Israel, Monaco, Morocco, Mauritania, all these other countries has reservations to this. And this is about the sovereignty of the state. But the fact of the matter is, Madam Speaker, if you talk about the optional protocols, please, if the Honourable Nawaikula can tell us, he should actually go and check himself. There are so many countries in the world that have not ratified the optional protocols, which is another step. Indeed, let alone even Britain. Even Britain has a reservation to UNCAT overall, saying whichever article they do not necessarily like, they'll have a reservation on that. So, Madam Speaker, the fact of the matter is that we should celebrate the fact that we have actually ratified UNCAT. UNCAT, Madam Speaker, has been in existence for decades. What happened to the other governments in Fiji? Why did not they ratify UNCAT? This government has ratified UNCAT. This government has said we're going to ratify other conventions. We are working on it. This government has allowed special rapporteurs to come to Fiji. We had the rapporteur this year that came, late last year on CERT. We had a rapporteur that came on education. We've got another rapporteur coming this year, and following every year we're going to get another rapporteur. We are, Madam Speaker, ratifying other conventions on the rights of persons with disabilities. There'll be before this House. Many other conventions, we've removed the reservation on CERT. We've ratified UNCAC. All these, Madam Speaker, international conventions we are signing up to. We've now complied with the ILO conventions. All of these progressive steps have been taken by this government, and the Honourable Nawaikula wants to simplify it without contextualizing it, homogenize the whole issues, and saying, are you going to implement the recommendations by this flawed report, which you have already answered to, Madam Speaker. Thank you.
Thank you. Now give the floor to the Honourable Leweri.
Thank you, Honourable Speaker. I'd like to thank the Honourable Minister for mentioning about police training with Scotland Yard. In terms of this, are there any plans to review the pay of the police officers to be on par with the military recruits? Thank you.
Honourable Attorney-General.
Madam Speaker. Madam Speaker, we can actually go on about the pay rise the police have received and the many other current policies we are reviewing, but that is not related to this, Madam Speaker. It's not related to this, Madam Speaker. And I'm sure Honourable Lavere, who is a former educationalist, Madam Speaker, would have the capacity to understand it's not related to this question. Thank you.
Thank you.